What's going on with Curtis?
We're going to be requesting an adjournment. We're going to have to get him a new attorney.
Okay, on the record in the matter of the people of the state of Michigan versus Kerry Curtis, file number 23-03378, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And good morning, Your Honor. Stephen Mills on behalf of Mr. Curtis. Mr. Curtis is present and standing to my right at this time.
How are you, Mr. Curtis? Today was the date and the time that was set for a preliminary examination. We reset this back in December because there was name and contact of a new witness that was provided. And now there's a need for a new attorney.
Yes, Your Honor. As the court may recall last time, we had to adjourn, and it was a long adjournment because we needed a statement from a necessary witness who came in, essentially saying, admitting to the crime itself. The officer that we had go out to go get a statement, turns out could not find the individual. I did collect a statement from this person, which means that there's a potential for me to go witness if this person is truly unavailable at some point. Because of that, I wouldn't be able to represent my client in his best interest, Your Honor. We would need to make sure we get an attorney for him in the event that I've inserted myself into this case. We were asking for probably about 4 weeks. My office get the attorney, and they can get caught up to speed.
4 weeks to get another attorney in your office, or are they going to be outside of your office?
My thought is it might have to be outside of our office. I think we've represented this individual before.
Okay. So next date.
May 2nd.
That election case, let me block a week off. From which one? The second action. She never got.
No.
May 2nd
10:30.
at 9:30.
Thank you, Your Honor.
No problem. Do you have any questions for the court today, Mr. Curtis? Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, the defense. Thank you.
Okay, we'll get you a copy of your notice to appear, Mr. Curtis.
Thank you.
You're welcome. I thought I see Mr. Byers in the meeting. Good morning, Mr. Biggleton.
Good morning, ma'am.
So what are we doing with Zavala Miranda?
I have not seen this Miranda this morning, Your Honor.
You've been in contact?
I have been in contact with her. I know she was aware of being here this morning. I was able to leave message with her, but I have not heard from her back. But I know she was around.
Okay, I'll issue a bench warrant. And then what about Greer?
Mr. Greer is present, Your Honor. No.
Last I checked, my victim wasn't here. If I could check the hallway just briefly, one more last check.
Yeah.
The victim on Greer is not present.
For the record, in the matter of the people of the state of Michigan versus Frederick Lamont Greer, file number 24-00158, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Greer, who's standing to my right this morning on.
How are you, Mr. Greer? Today was the date and the time that was set for a preliminary examination. There was count of home invasion first. There was an assault with, there's 2 counts of home invasion first. Count 3, assault with a dangerous weapon. Count 4, weapons, felony, firearm. Count 5, weapons, felony, firearm. Count 6, malicious destruction of personal property, $200 or more, but less than 1,000, and then an habitual offender notice. Matter was scheduled for a exam today, and there's no witnesses.
That's correct, Your Honor. Mr. Witnesses have failed to appear. The people are unable to proceed.
Counsel,
Your Honor, the defense stands ready to proceed today. We are motioning the court to dismiss this matter. We are aware it is without prejudice, could choose to file with unanimous.
do you have any questions about that?
No, man.
Okay, we'll get you a copy of your dismissal, okay?
Yes, ma'am.
Thank you. You can have a seat. On the record, in the matter of the people of the state of Michigan versus Matthew Heath Green, file number 24-00295 FY. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people. Aaron Robinson, Assistant Public Defender for Mr. Lee.
How are you, Mr. Ream?
Good, man.
Oh,
Judge, can I approach?
yes. Okay, Mr. Ream, today was the date and the time that was scheduled for a preliminary examination, count 1 of assault with a dangerous weapon, count 2 and 3, a police officer assault resisting obstructing, and there was an habitual offender second offense notice. I have a plea sheet here. It says the people are offering for you to plead guilty to an amended count of attempted resisting obstructing police and an amended count of assault and battery, dismissing the remaining counts and the habitual offender notice. Is that your understanding of your plea offer?
Yeah, sure.
And did you want to accept that offer?
Yeah, sure.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yeah, sure.
Thank you. Actually, the signature page, Scale made a two sheet page.
Yeah, I didn't know if they could attach it, so I just had them sign it at the bottom, but
Yeah, that Scale made it two pages. I don't know why they did that.
I said we did it to keep light. Oh, yeah. Few less trees.
Yeah.
It's wonderful.
Yeah.
24-00295.
Thank you.
No problem. Okay, and so you've read this advice of rights, sir?
Yes, ma'am.
You understand each of the rights listed here?
Yes, ma'am.
Are you willing to give these rights up?
Yes, ma'am.
You understand that you have the presumption of innocence?
Yes, ma'am.
You understand you're innocent until proven guilty, correct? You have the right to require the prosecutor to prove your guilt at trial. You have the right to jury trial. You have the right to see, hear, or question any other witnesses that the prosecution intends to call against you. You have the right to call your own witnesses or present evidence that you believe show a defense of the charges being brought against you. You have the right to remain silent at trial and not have silence be used against you. You have the right to require the prosecution prove each element of the charges being brought against you beyond a reasonable doubt. And you want to waive all of those rights today?
Yes, Your Honor.
Give that to him. Right, threatening you to get you to waive those rights?
No, Your Honor.
Has there been any promises made to you in exchange for a waiver of your rights in a guilty plea?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
You understand that a guilty plea could result in a conviction that you may need to report to your future employer.
Yes, Your Honor.
A guilty plea could also have impact on where you can get a travel or immigration status. You understand that?
Yes, Your Honor.
As to amended count one of attempted resisting obstructing police, how do you plead?
Guilty.
And as to the amended count of assault and battery, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Actual basis, please.
On February 3rd of 2024, were you at the CATA bus station on 420 South Grand Ave in Lansing, Michigan?
Yes, Your Honor.
Okay. And did you come into contact with some officers at the time?
Yes, I did.
And did you know that they were police officers?
Yes.
Okay. And when they asked you to stop, did you obey their commands?
No.
Okay. And they had a reason to stop you at the time?
Yes.
And one of the officers. When they were trying to arrest you, did you have physical contact with them?
Yes.
Okay. And you actually pushed them, correct?
Yes.
And it was not consensual
Yes.
and it was not in self-defense?
Yes.
Any questions from the prosecution?
No, Your Honor.
The court satisfied with the factual basis, I'll accept your plea and I find you plea to be made freely, voluntarily, and intelligently. This matter is scheduled for sentencing April 26th at 9 o'clock in the morning. You're being held on anything other than this?
No, Your Honor.
Need to meet with our probation department so they can provide the court with a pre-sentence report. They need to do an investigation. And so if you're still in the custody of Ingham County Jail, they'll make arrangements that way. But if for some reason you are released from Ingham County Jail, you need to report to probation within 48 hours of your release, okay?
Yes, Your Honor.
And we need a valid address if you are going to be released, okay? Any additional matters for the record?
Deeply, Your Honor. Judge, may it be heard on bond?
You may.
We'd be asking for Mr. Ream to have his bond converted to a personal recognizance bond at this time. After having pled to misdemeanors, I believe he's done about a couple weeks in jail now, understands that he needs to come to court. He has been staying at some of the local shelters and will promise to appear. I don't have any reason to believe that he wouldn't at this time, so we would ask for his bond to be converted to a personal recognizance.
Bond is admitted to 1,000 personal recognizance with GPS tether. All your previous bond conditions, including a no contact order for an Alex Martinez, and not engaging in any assaultive or threatening behavior, not using, purchase, or possessing a firearm or any other dangerous weapon, and not using, purchase, or possessing alcohol or drugs, and not travel outside the state, all will continue. Any additional matters for the record today?
Nothing for the people.
No, Your Honor, thank you.
You're all set.
Yeah.
They need to watch that when they arraign. My name, signature should not be there. I didn't issue that bond. She did. Let's see. Who's on Barnett? You on Barnett?
Good morning, Your Honor.
Which matter are you here for?
Myself and
Bauer,
Mr.
Your
Bauer.
Honor.
I think Mr. Piper's on Barnett. I can go get him. I
You're here
think
for Bauer, and we're doing a waiver.
Yes, Your Honor.
You can bring Bauer up.
Thank you so much, Your Honor.
Thank you, Ron.
Morning, Your Honor.
Good morning.
How are you today?
I'm well. How are you?
I'm well. Thank you for asking.
Let's see. You have Mr. Weck with you.
I do, Your Honor.
Okay, nice suit.
Thank you. The real game is right here in the pocket.
Oh, gosh. I should have never said nothing, right? Gosh. Okay, let's see. Are we ready on WEC? What are we doing?
We're gonna adjourn 2 weeks for PCC.
Another PCC
Yes, Your Honor, and we should have a result at that time.
on the record in the matter of the people of the state of Michigan versus Ryan Lee WEC, file number 23-03515. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Edward Zany on behalf of Mr. Weck. He is present to my right.
Okay, let's see. Mr. WEC, how are you?
I'm all right. How about yourself?
I'm doing pretty good. Okay. Today was the date that we set for a preliminary examination, but my understanding is that we need to have a new probable cause conference in hopes to resolve this issue.
That is accurate, Your Honor.
We already waived the timeline, so any objection to resetting this?
No objection.
What's your new date?
Maybe March 15th, 8:30.
That works for you, Mr. Zany?
It will, Your Honor. Thank you.
Okay, do you have any questions for the court today, sir?
No, ma'am.
Additional matters for the record?
Nothing from the people.
None from the fence. Thank you, Your Honor.
Thank you. Have a good one.
Have a great one. Thank you. Thank you.
You have Olivia Riley as well.
I do.
She present?
Yes, she's here.
On the record in the matter of the people of the state of Michigan versus Olivia Riley and file number 24-00196. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Aaron Robinson, Assistant Public Defender for Ms. Riley.
How are you, Ms. Riley?
Good, how are you?
I'm well, thank you. Just need to get her to sign this signature page, please.
The one that we just talked about. This is just the second page that. you have to sign this.
Thank you. I've already taken her.
The first page, yeah.
Yes, okay, sounds good. Okay, so. Looks like you were scheduled to have a preliminary examination on a motor vehicle unlawful driving away. The people are offering for you to plead guilty to an amended count of malicious destruction of personal property. Less than 200, no objection to sentencing under HYTA. That's accurate?
Yes, Your Honor.
It is.
You want to accept that offer?
Yes, ma'am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Thank you. You can put your hand down there. Okay, you read this document?
Yes, ma'am.
You understand this is advising you of the rights that you would be giving up in order to accept that offer?
Yes, ma'am.
So you understand that you have the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt at a jury trial. You have the right to remain silent at your trial and not have silence be used against you. You have the right to see, hear, or question any witness the prosecution intends to call against you. And you have the right to call your own witnesses or have evidence presented at your trial that you believe show a defense to the charge being brought against you. You understand that? You also have the right to remain silent at your trial and not have silence be used against you. Do you have any questions about those rights? Anybody making any promises to you to get you to waive your rights?
No,
Any threats being made to you in exchange for a guilty plea on this?
no, no.
Okay, you understand that although the prosecutor is not objecting to sentencing under HYTA, that's not essentially an offer that you can count on. I have to know that you're eligible for HYTA first, okay? Okay,
Thank you.
okay, do you have any questions about that?
No,
Okay, as to, and you're not on probation or parole at this time, are you?
no, no.
Okay. As to the amended count of malicious destruction of personal property less than 200, how do you plead? Factual basis, please.
Yes, Your Honor. On January 5th of 2023, were you at the area of 1425 Renson Street in Lansing, Michigan?
Yes,
Otherwise known as PJ's Towing Lot?
yes,
Okay, and you had your car that was parked in that lot at the time?
yes,
Okay. And when you were there, did you move the car through the gate, damaging the lot?
yes,
Okay. And you did that knowing that you didn't have any permission to do that?
yes.
Any other questions?
No, Your Honor.
Is there restitution?
Restitution was already paid.
Okay. We're satisfied with the factual basis. I'll accept your plea. I find your plea made freely, voluntarily, and intelligently. This matter is set for sentencing April 26th at 9 o'clock in the morning. When you leave here today, you need to go down one floor to the 5th floor and check in with probation so they can get you set up for a pre-sentence interview, okay?
Yes, ma'am.
Do you have any questions for the court at this time?
No.
Additional matters for the record, counsel?
Nothing from the people.
No, Your Honor, thank you.
You're all set. Mr. Bauer is not there.
I'm gonna make some calls, Your Honor.
Okay, sounds good. We can bring up, you're gonna go take her down and then you can bring up Barnett.
Yep.
Have you seen Ms. Wanji?
She's in the hallway.
I wonder if we have Ms. Harris here.
It looks like it.
Oh.
At least based off of the
So you
Zoom.
can come in.
Did they say why?
Why what? She must send her. I wanted her to bring him the knowledge.
So,
Is Mr. Greer out there? We have his Nolly right here, if you want to bring him a copy. Ms. Petrowski,
yeah, save your,
well, you gotta bring him a copy. He can't come up here and get it.
oh, yeah, then, sit tight. Sorry. It's
On the record in the matter of the people of the state of Michigan versus Mary Jean Harris, file number 19-03855, council appearance.
Prosecutor Paige Petrowski on behalf of the people.
How are you, Ms. Harris?
Good, how are you?
I'm well, thank you. Today was the date and the time that we set this for a show cause, or reset it, I say for show cause. And the reason or purpose for the show cause is because Ms. Harris was supposed to undergo a forensic evaluation, and the court received notice that she failed to appear for her appointment. Why is that?
Well, you know, I think that I should take also part of the responsibility for that. I don't understand, my client is very confused. And I was sending her the information, I was sending her reminders. And our office also sent her a letter, but it's my understanding that the family was not aware of the appointment. So we have taken some immediate steps. I have the husband's cell phone, and we intend, if they set up another appointment, to make the family aware of that appointment so they can make arrangements to take her to Eastland for the evaluation. If I may also, the court may have seen last time when Ms. Harris had tried to zoom in and she was very confused and she didn't really know how to do that. And she did not have a ride, and but today she did make sure that she came here in person, and we have discussed, and I believe that she would be at the next appointment.
Was the family member responsible for getting her to these appointments? Because the forensic center is requesting her to be detention for this purpose. Because they can't just be setting appointments and people not show. There's a large amount of people who need to have evaluations. It's a costly endeavor to the public to schedule these and then not have the defendant appear for that evaluation. So who's supposed to be responsible for that?
Well, I have the son and the husband.
Is that those individuals in the back?
Yes.
What's your name, sir? Sammy Harris?
Yes.
You're the husband?
Yes.
And your name, sir?
Sammy Harris,
Sammy Harris Jr.?
third.
The third? Okay. And so you all are her caretakers?
Yes.
Okay. And so were you aware that she was supposed to have a forensic evaluation? So you were not present when I ordered her to undergo a forensic evaluation?
Yes, ma'am.
Yeah.
I thought you were. And so have you been in communication with her attorney?
No.
Okay, I think that's part of the problem. She's got to undergo a forensic evaluation. The court's ordered it. I ordered it back in October. Now we're in February. And so I'll reorder. I'll issue a new order so that this can be done. If you all cannot work together with the attorney to make sure she's there, I have no choice but to have her placed in detention to get it done. Okay? Do you have a question?
Well, I'm gonna next question.
We're going to do
Okay, so you have contact information with the attorney now?
that. Yes.
Okay, so we'll issue a new order to have it reset. And then once it's reset, Ms. Wanji, you will make sure that her caretakers know of the date so that it's not missed, okay?
Okay, no.
Okay, we'll get new paperwork together for a new order to undergo forensic, and then we'll set it for a new review date. We probably need a minimum of 60 days for review.
Yeah, conference, I have to do.
For review date?
Yeah.
Okay, we get the review date in the mail because I'm not able to set it at this time. Is the mailing address changed at all for you? Any questions from the court? For the family? Any questions? Any additional matters for the record?
No, you're nothing.
Your Honor, thank you.
Thank you, you're all set.
So Robert is definitely here.
He's here.
Yeah, I just went down there.
Bring them up after this.
He's in the board, and we did see them out of the extra security. So he said he's gonna be here as soon as possible.
I'm sorry?
Mr. Pfeiffer, is in ward. Apparently he's handling something where there's need for extra security, so he's trying to get that done as quickly as possible.
Oh, he's on this matter?
Yeah, and he's on, yes, partner.
Okay.
Sorry, I should have clarified that first.
Sure, let's see if we can get this, if P radio and have security
sir,
bring
right
up
here.
Bauer, please. You can radio up security, they can bring up Bauer.
Okay, can you guys stand on your seats, crew?
Welcome going, you can go in the jury box. Just go right there. Please go get another inmate. Thank you.
I'm worried I'm gonna create a security risk, so they need supervision for me.
Oh, I don't know that.
Have you been east at all lately?
Not since the holidays. Yep, so. We'll see. Okay, on the record in the matter of the people of the state of Michigan versus Matthew Bauer, file number 23-03115, council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson. Bring on behalf of Matt Fowler, who's standing to my right this morning, Your Honor.
But somehow misplaced my docket sheet. I might have stuck it in somebody's file. Can you see if I put my docket in that, in the file there? There it goes, thank you. Okay, Mr. Bauer. Today was the date and the time that was set for a preliminary examination and a bond show cause. Let's see, where is it set for bond show cause?
Your Honor, he was originally released on tether and allowed that tether to either die or fail to pay. I can't remember which it was, but either way, he was rearrested for not having that tether functioning, maintained, all of those things.
Mhm. Let me see if I see that in here. Okay. That should comply with GPS tether requirements. I see that. That was signed in November though. And then I have a, looks like I revoked just for phone purposes in December. Okay. My understanding, there's an unconditional waiver today of the examination.
Yes, Your Honor, the people and the defense are prepared to unconditionally waive their right to a preliminary examination. Ask that you bind this case over as charged to the circuit court. We do have a plea agreement there that I'll state just for this record. It's for the defendant to plead guilty to both counts 5 and 6, which are criminal sexual degree. And the second, as a habitual offender third, there is a Killebrew to a fixed minimum of 18 years. And with that, the people would dismiss the remaining charges, would also dismiss the pending case against the defendant's co-defendant, which is his mother, Patricia Walker. And that offer is going to stay open until our first hearing in the circuit court, whether that's arraignment or pretrial.
Okay, counsel?
Your Honor, that's an accurate statement of what we wish to do today with the examination.
Okay, and so, Mr. Bauer, you understand that you have the right to have a preliminary examination here in the district court.
Yes.
I understand the purpose of that examination is to require the prosecution to put forth evidence to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you.
Yes, ma'am.
Okay. Are you willing to unconditionally waive that today?
Yes, ma'am.
Anybody threatening to get you to waive your examination?
No, ma'am.
Has there been any promises made to you in exchange for a waiver?
No, ma'am.
And you understand that the waiver, you can't change your mind. You can't get to circuit court, decide, you know what, I don't like the offer. I want to have my exam. Once you waive it, it's gone. You understand that?
Yes, ma'am.
Your bind over date's gonna be March 6th. The circuit court's gonna get the file from the district court. That's not a next court appearance for you, okay?
Okay.
Your next court date will be a pretrial. Everything will be made aware of that date. You be in contact with him, okay?
Okay.
I have, you all sign this, please.
Is purple, okay?
That's what I sign into. so.
Okay.
Are we adjusting bond today?
Judge, we are with regards, to what I ask is, that he had his video and his phone privileges, stripped, Your Honor. I know there were some allegations of contact with his family, Your Honor. I'd ask that he be allowed to have visits. His brother and his father are here in the courtroom today. And I don't believe he wished to have any discussion about the case with his family. But I think not to be able to make contact with his family, particularly when he's in a correctional facility. So I'd ask that he be allowed to have video visits with his brother and father.
Counsel.
The defense had approached me to see if I would agree to this. I told him after the time of plea, I would agree to have the modifications lifted at the court's discretion. But at this point, the case is still pending. We have this agreement in place. I would hate for anything to happen between now and then that could put a wrench in this. As we've seen, there already has been witness interference, intimidation. In fact, the defendant's mother has already been charged criminally, been arraigned, and had a PCC on that matter. The agreement is to dismiss that case if Mr. Bauer's plea goes through. But ultimately, what I think happens is if Your Honor modifies, we have a 2 to 4 week span where this plea could blow up. And that would be bad for Mr. Bauer as well as for everybody else. So I would recommend that they stay as is and we consider modifying them after the plea's been entered.
You see, on December 28th, the court was advised of allegations, calls made by the defendant to family members to make it more difficult for them to come to court. Those are allegations of intimidation against the witnesses. And then we also obviously have the issue with your GPS tether, I think just before that. I think it's in the defendant's best interest that if he wants to soften that his restrictions continue, because we run the risk of things not going as they're supposed to if he's having communications with his family that could lead to further allegations of intimidation. So I'm not going to amend either the bond, nor am I going to amend the order restricting contact at this time.
Thank you, Your Honor.
Any additional matters?
Nothing from the people. Thank
Nothing
you.
on behalf of the defense, Your Honor. Thank
You're
you.
all set. Thank you.
English when I get back to the office and see if we can get it for an arraignment. So I'll let you know.
Mom.
Okay, have a good weekend, everyone.
Have a good
Thanks,
one.
Judge. Yeah, thanks, guys.
Still waiting for Mr. Kreisberg, correct? Ms. Donnelly, did you have someone?
Yes, Gavin Bombers is downstairs. He's gonna waive his.
Wow, them brought up.
Dale, can you bring up Gavin Bombers?
What happened to is Mr. Carter here?
Oh, I haven't seen him.
Mr. Kurt for Thomas Hodge.
Yes.
So I can pull up the email, but I believe he is in another court and he was also just assigned. So he was, we were gonna set out for another date for freedom.
So did you sign the
Sorry, I-
substitution?
He's gotta come and waive then.
I understand. I'm just.
Oh, I haven't seen him.
Judge, I wasn't on that case before. Did you assign the order? Because I think
I've not signed it yet.
Want me to wait 20 days with him?
Yep, we need to wait it.
And then you can sign the order and
Yep.
then, perfect. Thank you.
I know, oh, okay, so he's in another county in court today.
Yes, we were telling us. yeah.
Okay.
Let's see. Just sticky notes, House of Commons, what does that mean?
What was that for? Something.
Evan Mitchell. Heather Salazar, ICJ.
Oh, can he be, so once he's released to House of Commons, does he have to? Can he just be done after he's done serving or doing?
How long is he gonna be in House of, how long is he gonna be in House of
They
Commons?
said they don't know, it varies. But I asked him
That's
that too.
fine.
Okay.
Apologies, there was an enhanced security hearing.
You just came running in here. I thought he was having a threat. Someone was
No.
chasing you.
Nope, it's been taken care of. I
Okay,
just knew
you're
I was-
good? You
I
don't
was
need me to
late.
give you any security? No one's
I'm
chasing you
fine.
down the hallway?
No, he was taken into custody.
Okay, sounds good.
DeAndre.
Oh, boy.
Go ahead. When the defense attorney is saying we're gonna need more security, I take them at their word. It was Palmer.
Oh, okay.
Oh, boy.
Yep.
That's credible, huh?
Right.
Okay, let's see.
Again, my apologies.
No worries. We handled some other people. On the record in the matter of the people of the state of Michigan versus Devery Barnett. I have file numbers 23-03771 and 770. Council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Jacob Sarr, support Assistant Public Defender here on behalf of Mr. Barnett. Present, he's at council table, he's staying.
How are you, Mr. Barnett? I'm well, thank you. Okay, today was the date and the time that was set for a preliminary examination. My understanding is that there will be an entry of a felony plea on file number 23-03771, and in exchange for that plea, the other file will be dismissed.
Yes, Your Honor.
That's correct, Your Honor. You've already been signed to Judge Aquilina. I believe the circuit court case number is already in the file. Mr. Barnett's prepared to waive his preliminary examination this morning, and there should be a signed advice of rights form already in the packet for you. Thank you.
Very good. That's how you want to proceed, sir? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, you understand that you have the right to have a preliminary examination in these files because you're being charged with felonies. And you understand the purpose of the preliminary examination is to require the prosecution to put forth evidence to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You're willing to unconditionally waive your right to examination? Anybody threatening you to do that? Any promises being made in exchange for that?
Here, the only thing I will say, the only other promise you might have gotten, part of the deal is that we would not pursue witness interference charges for contacts prior to February 15th. So just for the record, to be clear, that is something else he was promised.
All part of the plea, okay.
Yes.
And that's noted on the paperwork for your honor.
Correct. Typically, when I'm asked if there are any promises, I'm not really referencing the plea. I mean, like if someone said, I'll give you $50 if you waive your right. That's what I mean. Like if there's something else outside of this plea that somebody is promising you to get you to waive. Okay, what about threats? To like anybody say, I'll crack your kneecaps or anything like that if you don't play? Oh, no one did that? Okay. All right, I'll bind the matter over to the jurisdiction of the circuit court. Let's see. And so now, acting as under the assignment of the circuit court, I think you're assigned for sentencing again before Judge Aquilina. And so you do consent to have your guilty plea or felony plea entered here at the district court and then be sentenced by another court judge over at the circuit court, correct? Okay, and the prosecutor is consenting to that? Mr. Piper,
Yes, Your Honor. Be glad
and
to present.
you're consenting as well?
Yes, Your Honor.
The
Thank you.
court, thank you. The court having already bound this matter over to the circuit court, but the formal information will not be filed until later. The plea today will be on the reading of the complaint or the complaint as amended. Do you waive the right to have the information provided to you today, as long as it substantially complies with the reading of the charges here today? Counsel,
Yes, Your Honor.
you waive the information, okay. Okay, the prosecutor, what counts will the defendant be pleading to? Can you state that on the record?
Yes, Your Honor. The agreement is for the defendant to plead guilty to count 1, felonious assault, to count 2, domestic violence, second offense notice. In exchange, people agree to dismiss the other file, that being file number is 233770 FY. And further, the people agree not to pursue witness interference charges in either file for contacts made prior to February 15th, 2024.
Okay, and can you read the charges that he's supposed to plead guilty to?
Absolutely, Your Honor. In the name of the people of the state of Michigan, prosecuting attorney for this county appears before the court and informs the court that on or about 8/18/2021 at 1300 Otto Street, that's OTTO, in the city of Lansing, Ingham County, the defendant for count 1, assault with a dangerous weapon, or felonious assault, did make an assault upon Amia Jones and or Mazuza Jones with a dangerous weapon, to wit a handgun, without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. This is a felony with a maximum punishment of 4 years and or $2,000. DNA is to be taken upon arrest. The consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Then for count 2, domestic violence, did make an assault or an assault and battery upon Amia Jones, an individual with whom he had a child in common, or a resident or former resident of his household, or an individual with whom he had a dating relationship, contrary to MCL 750.812. There could be restitution if this offense resulted in damage to another individual's property or physical injury or death to another individual per MCL 780.811A. This is normally a misdemeanor with a maximum penalty of 93 days and or $500, with a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. But under the second offense notice, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating MCL 750.81A2 on or about 7/26/2012, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.814. This now becomes a misdemeanor with a maximum penalty of up to 1 year and or $1,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. The court shall order law enforcement to collect a DNA identification profiling sample for sentencing disposition if not taken at arrest. This is against the peace and dignity of the state of Michigan.
Okay. Mr. Barnett, can you raise your right hand? Please solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Count 1, assault with a dangerous weapon, that's also known as felonious assault. You understand that charge?
Yes, ma'am.
You understand that is a maximum penalty of 4 years and or $2,000 of fines, correct?
Yes, ma'am.
Your DNA is to be taken upon arrest and there's a consecutive sentence imposed under the law if the assault was committed in a place of confinement. You understand the maximum penalty?
Yes, ma'am.
Okay, and then domestic violence, again, is a misdemeanor, but the penalty is 93 days in jail and or $500 in fines. Do you understand that?
Yes, ma'am.
You also understand that there's a second offense notice, and so it enhances the sentencing to 1 year and or $1,000 in fines. Understand that? Okay. Are you currently on probation or parole?
Yes, ma'am.
Which one?
Okay.
You understand that if you enter a guilty plea, that could have an impact on your probation or parole status.
Yes, ma'am.
Okay, and you discussed that with Mr. Sarks. Okay. And if you've ever been convicted of a felony in the past, you could be subject to the penalties of an habitual offender. You understand that as well?
Yes, ma'am.
Okay. You understand the rights that you waived when you signed this felony plea of rights of rights?
Yes, ma'am.
That's your signature there at the bottom?
Yes, ma'am.
Okay. And so you understand that you have the right to the presumption of innocence. You're innocent until proven guilty. Can you say that a little louder for us?
Yes, ma'am.
Okay, and you're willing to give up your right to be presumed innocent?
Yes, ma'am.
Okay, you have the right to have the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt before you are guilty. You understand that?
Yes, ma'am.
You have the right to have witnesses called against you to appear at trial. You understand that?
Yes, ma'am.
You have the right to question the witnesses against you. You understand that?
Yes, ma'am.
And you have the right to have the court order any witnesses you have for your defense to appear at your trial. You recognize that as well?
Yes, ma'am.
You have the right to remain silent at your trial and not have silence be used against you.
Ma'am.
And you have the right to testify at trial if that's something you chose to do. You understand that?
Yes, ma'am.
And you're willing to give up each of those rights to plead guilty?
Yes, ma'am.
You also give the right to make any claim that the plea was the result of promises or threats that were not disclosed today on the record. And I previously asked you about that, but I'm gonna ask you again. Any promises or threats being made to you to give up the rights and enter a plea today?
No, ma'am.
And you also understand that any appeal of your conviction and sentence would not be automatic, but you would have to ask for permission to appeal your conviction to the Court of Appeals.
Yes, ma'am.
You would have the right to request counsel if indigent for the purposes of your appeal. You understand that?
Yes, ma'am.
For the purposes of the record, can you reiterate the agreements for the plea?
Yes, Your Honor. The agreement is for the defendant to plead guilty to file 23-3770 FY, which was found over the circuit court as charged, exchanged, people agreed to 3771 FY, mistake. In exchange, the people agreed to dismiss file 23-3770 FY and not pursue witness interference charges for contacts made prior to February 15th, 2024.
That's an accurate understanding of the plea.
Yes, Your Honor.
Are you entering a guilty plea because you believe you're guilty?
Yes, ma'am.
Okay, as to count one of assault with a dangerous weapon, also known as felonious assault, how do you plead?
Guilty.
As to domestic violence. Second
Guilty.
offense notice, you plead guilty as well?
Yes, ma'am.
Factual basis, please.
Thank you, Your Honor. Mr. Barnett, on August 18th, 2021, 8/18/2021, we were at the location 1300 1300 OTTO Street, in the city of Lansing, in Ingham County, in the state of Michigan. Were you at that location?
Yes, sir.
Okay, and on that date and time, did you encounter Maya Jones at that location?
Yes, sir.
And you have a relationship with Maya Jones, correct? You have a child in common?
Yes, sir.
And on August 18th, 2021, at that location, did you have some type of argument with Maya Jones?
Yes, sir.
Did that argument escalate?
Yes, sir.
And at some point, you got really mad at her and you pushed her, right?
Yes, sir.
And when you pushed her, she didn't give you consent to push her, correct?
Right.
And when you pushed her, you did not push her out of self-defense, correct?
Right.
So you pushed her intentionally, correct?
Yes, sir.
Okay, and after you pushed her, the argument continued. You were still really mad at her, correct?
Yes, sir.
And at some point, after you pushed her, you went into your residence, which is at 1300 Auto Street, correct? In the city of
Yes, sir.
Lansing. And when you're inside the residence, you grabbed a BB gun, correct?
Yes, sir.
And that BB gun looked like, or it could be misconstrued, or it could be misunderstood to be a handgun, correct?
Yes, sir.
And you were so mad at her that you went back outside, and you raised and pointed the handgun in her direction, correct?
Yes, sir.
And obviously you weren't intending to try to kill her or anything like
No,
that.
sir.
or inflict any great bodily harm,
No, sir.
less than murder, but you were trying to scare her with it.
Yes, sir.
And you could understand why she would be afraid of maybe being shot by a pellet or having some type of injury inflicted upon.
Yes, sir.
So you understand by raising a BB gun in someone's direction, you're putting them in a fear of potentially being bad.
Yes, sir.
And it was dark at times, so you could understand too that she might have mistook it for an actual fire. Right?
Yes, sir.
Okay, thank you, Your Honor.
Any questions from the prosecution?
Yes, Your Honor. I don't believe that is sufficient factual basis for count one. Mr. Barnett, was your intention for her to believe that it was a firearm?
No, sir.
And I don't believe we have a guilty plea, Your Honor.
You raised, sorry, Your Honor, may I? Thank you. All right, when you went outside with this BB gun, you understand it looked like a real fire, correct?
Yes, sir.
Okay, and you understand that she could view this as a fire.
Yes, sir.
Okay, so when you raised the firearm in her direction, you intended with an object that looks like a real firearm to put her in fear of an imminent death.
Yes, sir.
I believe that's sufficient, Your Honor.
And just to clarify, you did have a prior conviction in 2012 for domestic violence, to the best you know,
Yes,
correct?
sir.
All right, thank you.
Court is satisfied with the factual basis, and I find it to be sufficient and established. I find your plea to be made freely, voluntarily, and intelligently. The court will also state on the record that affirmatively that it has not agreed upon sentence with anyone involved in this case. Counsels, are you aware of any promises, threats, or inducements for this plea other than what was disclosed on the record?
No, Your Honor.
No, Your Honor.
Okay, counsel, do you believe that the court complied with Michigan Court Rule 6.302 and the local administrative order following the felony plea in district court?
Yes, Your Honor.
Court has, Your Honor. Thank you.
Okay, again, the court finds the plea to be accurate, voluntarily, and understandably made. The plea is accepted. The matter is going to be transferred to Judge Aquilina for sentencing. The sentencing date is going to be April 2nd, 2024, under Circuit Court Case Number 24-120FC.
Thank you, Your Honor.
And no problem, and I think I've also signed an order that would require DNA sample collection as well. I did. Okay, let's see here. Any additional matters for today's record?
Just so I place on the record after everyone please, that per the court rules and the law, if the defendant is to commit a misconduct between today's date, the sentencing date, and April, he would lose out on the benefits of the plea deal, that being us not pursuing charges of witness interference, as well as the other
Reinstating
case
it.
in its entirety. And he wouldn't have the ability to withdraw his plea for it to happen. I just want to make sure that the defendant is made very clear about that.
Do you have any questions about that, Mr. Barnett?
No, ma'am.
Okay, file number 23-03770FY is dismissed per plea. I think we need a nollie on that.
Gotcha.
Thank you, Your Honor.
Thank you. We'll get you a copy of your nollie before you leave, okay? Ready? This is notice for sentencing. Do we have one more person? Okay, okay, sounds, okay, and then we need Hodge, right? Mr. Michelson going to handle the waiver of timeline for Hodge.
Thank you.
That'd be great. What's this here?
I always request it online. Just points muscle memory.
You all waiting for something?
No, we're just here to view. We're
Oh.
congratulations.
Okay, on the record of the matter of the people of the state of Michigan versus Thomas Hodge, file number 24-00293, council appearance.
Prosecutor Kate Petrowski on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Thomas Hodge, who's standing to my right this morning, Your Honor.
Okay, how are you, Mr. Hodge? Understandable. Okay, today was the date that was set for a preliminary examination. My understanding is that there is new counsel, is it Scomper counsel?
No, Mr. Carter's been retained on this matter.
Okay, you've retained an attorney, Mr. Carter. He did submit to the court a substitution, which I've not signed yet. And the reason I haven't signed is because he was unable to appear today. And you have the right to have your examination within 21 days of your arraignment date. So you were arraigned on February 2nd. And so I need to know if you're willing to waive your timeline because your new attorney needs to get ready to present your defense. So are you willing to waive the timeline so I can have this reset?
Yes, ma'am.
Anybody threatening you to do that?
No, ma'am.
Any promises being made to you to waive your timeline?
No, ma'am.
Okay, so I'm gonna sign the substitution of counsel so that Mr. Carter's appearance will now appear as your attorney of record. We'll reset this matter. I don't know what his schedule is because he's not here. So it's likely this will be reset again if that date doesn't work for him, then he'll let us know.
Yeah.
I'm gonna set it for a new PCC and then a new exam.
What's PCC?
You had a probable cause conference last week.
Yeah.
Same thing. That's what the PCC is.
No.
We do PCC March 15th at 8:30. And then exam April 4th at 9:30.
You have any questions about that? Okay,
Judge, I'll give those dates to Mr. Carter when I email him the sign slip that I get back today, and I'll advise him what the court knows, so he has issues with those dates.
okay. I'll note that in the file. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing back to the fence.
You're all set. Thank you, Mr. Carlos.
No, thank you, Your Honor.
Record in the matter of the people of the state of Michigan versus Gavin Von Brees, file number 24-00297 FY, council appearance.
Assistant Prosecutor Kate Petrowski on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Gavin Bombers, who is present and standing to my right.
How are you, Mr. Von Brees? Okay, today was the date and the time that was set for a preliminary examination for retail fraud first. How are we proceeding?
Understanding that the defendant would be unequivocally waiving his right to a preliminary examination and proceeding to the circuit court, the people would also unequivocally waive this right in the case be found over as charged.
Council,
That's correct.
any offer?
There's no offer currently.
Okay, Mr. Von Brees, you want to waive your preliminary examination? Sure. You understand that you have the right to have a preliminary examination, and at the time of that examination, it is your right to require the prosecutor establish that they have sufficient evidence to support probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yeah.
You're willing to unconditionally give up that right to examination? Anybody threatening you to get you to do that?
No.
Has there been any promises made to you in exchange for you waiving your exam? Anybody promise you anything if you waive your exam?
Possibly.
Someone promised you a PR bond?
No one promised you anything, right?
Excuse me?
Then I don't know what.
You don't want to waive it? Oh, okay, well, there's that. He thought he was getting a PR bond for a waiver, so we can have your exam then.
You wanna have, again, you wanna bring in the officers and have testimony to make sure to establish that you wanna do that? All right. All right,
Okay, we did not have officers today, is that correct?
We did have an officer today, but
Oh, we did,
We
but
might have released him under the understanding that he was waiving.
I did, but I can call him and get him back.
Okay, sounds good. We can go off the record so you can call your witness and you can in the matter of the people of the state of Michigan versus Gavin Bombriz. Mr. Bombriz, did you rethink your decision about what you want to do, what's your right to have your exam? If you want to have your exam, we can have it.
I wouldn't do it.
Are you sure? You seem
Yes.
dejected about that. Are you
I'm just not
disappointed?
gonna waste your time.
You're not wasting my time. They pay me to be here to do this. That's why I'm here. I came here today to give you your right.
Okay.
So you don't get to say that it's a waste of the time. It's your absolute right to have it, and you don't have to waive it if you don't want to. You can have it. We can get the witness here, okay? Is that what you want?
I would waive it for that.
Okay, well, when you waive it today, it's gone. You don't get to change your mind later. You understand that?
Yes, ma'am.
So you're confident this is how you want to proceed?
Yeah.
Okay, anybody threatening you to get you to waive your exam?
No,
Any promises being made to you?
no.
Who needs to sign that? You understand that once this matter gets to circuit court, you can't change your mind if you don't like your plea offer, or you can't change your mind if you don't get a PR bond. You understand that? Okay.
Yeah, exactly.
Your bind over date's gonna be March sixth. That's the date that the circuit court's gonna get the file from the district court, okay? You do not need to appear in court on March sixth, okay, sir? Your next court date will be a pre-trial. It'll be in circuit court. Ms. Donnelly will be made aware of that, okay? The bond was set at 3,000, 10%. Let's see. I'm assuming there's a request to address bond.
Yes, Your Honor, I would just say that he has been in custody for 16 days. He does still have court review on a remand next Tuesday, so he is requesting a PR bond, knowing that he still has to sit until Monday. Monday, oh, you're right, you have court on Monday and Tuesday, so he knows he's gonna still be in custody until then, but he also has a warrant out of Eaton County, but yes, he wants.
I see him on Monday, you said?
Yes.
For what?
There is another, well, he has, on Tuesday is the assault and battery that he failed to appear for. On Monday is a ticket.
City stuff? So I see him on Monday or Tuesday?
Trespass, yes, on Monday
Oh, okay.
and on
Sounds-
Tuesday.
I see him on Tuesday too?
Yeah.
Wow. Okay, let's see. What's Tuesday for?
Domestic violence.
I'm sorry? Retail fraud. And a retail fraud, okay. So he wants me to amend this bond to a PR bond?
Yes, he can't afford the cost of it right now.
What's your address, sir?
I do not have that money.
So you gave no address, no mailing address, no phone, and you want me to PR you?
He says you do have someone to stay with. You have your girlfriend, Ms. Perkins. You just don't know her address.
I don't know their address.
What's Miss Perkins' first name?
Cerise,
Oh, okay. She lives in Lansing?
all of that.
She lives in Olivet, okay. And how are you gonna get back and forth to court?
She works Monday through Friday, so I would be.
Oh, she comes to Lansing for work is what you mean?
Yeah, she works.
Okay, why don't you work?
I need to find it.
Exactly my sentiment, but I'm just wondering why you haven't found any already.
It's kind of hard with my arm.
What's the matter with your arm?
I've been shot. So.
Oh, so you have an injury? Oh, okay.
You still need surgery on it, right?
Okay,
I'm
got it.
supposed to go back on 14th.
Okay, so you were working before you got shot? Okay. I'll make your bond to 3,000 personal recognizance. You need to provide a valid address and phone number within 48 hours of release. You gotta provide that to pretrial services, okay? Do you have any questions? Any additional matters for the record?
Nothing, particularly, Your Honor.
Nothing for defense.
You're all set.